Hello and welcome. This is a presentation to review and provide updates for tenants who have been displaced by the January 2024 floods in San Diego. It was recorded in May 2024 in anticipation of vouchers expiring June 21st, 2024. Please note that information for homeowners is not included in this presentation. This presentation is intended to provide general information regarding legal rights related to housing. It is not legal advice. After viewing this presentation, if you still have questions, please consult with an attorney or the appropriate agency about your rights in your specific situation. Or call Legal Aid Society of San Diego at the number on this screen, or visit www.lassd.org. This presentation will answer 5 questions. Number 1, does a tenant need to pay their rent if their landlord made the tenant move out during the repairs? Number 2, can the landlord terminate a tenancy because of flood damage to the unit? Number 3, who pays for a tenant's temporary housing while repairs are being made? Number 4, who is responsible for the repairs in the unit? Number 5, who pays for the damage to a tenant's personal property? Please note that when the term landlord is used, it is meant to refer to the owner of the property, but includes anyone acting on their behalf, including property managers. Let's start with the first question. Does a tenant need to pay their rent if their landlord made the tenant move out during repairs? Even though the unit may be damaged, a tenant is still responsible for paying rent absent a communication from their landlord otherwise. A landlord has an equally important obligation to provide safe, habitable housing. If the landlord pays for that safe temporary housing, the tenant likely still has an obligation to pay rent to their landlord. If an insurance company or a public agency is paying for the tenant's safe temporary housing, the tenant can share that fact with their landlord and ask for relief from rent while the landlord is not paying for that safe temporary housing. If neither insurance nor public agency nor the landlord is paying for the temporary housing, the tenant may ask for reimbursement from the landlord. Choosing not to pay rent altogether may place the tenant at a very high risk of eviction. If a tenant receives a 3-day pay rent or quit notice, they should call Legal Aid Society of San Diego immediately. Question number 2. Can the landlord terminate a tenancy because of flood damage to the unit? The quick answer is no. Flood damage alone will not automatically terminate your tenancy. A landlord who wants to evict a tenant must follow the laws, which require, first, a properly served written notice, second, a lawsuit for possession and a court order granting possession to the landlord, and number 3, a request to the sheriff by the landlord to execute the order and remove the tenant. Landlords are not allowed to change locks, remove tenants' belongings, or cut off the utilities. If a landlord does any of these types of illegal self-help actions, a tenant can call the non-emergency law enforcement number for help. Keep a copy of all communications with the landlord during this time for proof of the lockout. Even though there is a formal process for the landlord to evict the tenant, landlords were not allowed to take any action to evict a tenant between January 24th and March 30th of 2024, if certain circumstances applied. The county passed this ordinance in response to the damage caused by the flood. This ordinance said that between January 24th and March 30th, a landlord could not serve an eviction notice, file an eviction lawsuit or serve an eviction lawsuit, nor seek an eviction judgment, nor otherwise induce a tenant to leave if the property was located in a flood-affected area and the landlord knew or reasonably should have known that the tenant suffered economic loss. The only exception to this ordinance allowed a landlord to evict a tenant if the landlord could show that a tenant's act or failure to act creates an immediate and serious threat to a person's health or safety. Flood-affected areas are the only zip codes listed on this slide. So if a tenant's zip code is listed on this slide, they were covered by that ordinance if they suffered economic loss and if the landlord knew or should have known. Economic loss is defined as reduced income, increased expenses, or other personal economic consequences directly or indirectly caused by the flood, including but not limited to lost work hours, loss caused by a landlord in the course of improperly evicting or requiring the relocation of a tenant, and damage to a tenant's property or to a tenant's unit, or a need to relocate because of damage to a tenant's unit or building. If the landlord tried to evict a tenant between January 24th and March 30th of 2024, a tenant can raise it as a defense in an eviction lawsuit, and a tenant can file a lawsuit against the landlord requesting money damages, mental or emotional distress damages, injunctive relief, and other relief the court deems appropriate. Question number 3. Who pays for a tenant's temporary housing while the repairs are being made? A landlord may be responsible for paying for a tenant's hotel or temporary housing because landlords have an unwaivable duty to provide habitable housing, and this duty continues even if there is damage to the unit that requires the tenant to temporarily leave the unit so that it can be safely repaired. As mentioned earlier, flood damage does not automatically terminate a tenancy. A tenant who had to move out for repairs to be safely performed can ask their landlord to pay for temporary housing, especially if the tenant has continued to pay rent. If the landlord refuses, a tenant should keep a copy of all receipts for hotel stays and food that has to be purchased daily because the hotel lacks proper food storage appliances. These receipts can be used to file a lawsuit to seek reimbursement. Question number 4. Who is responsible for the repairs in the unit? It is the landlord's sole responsibility to make repairs to the unit. Landlords have an obligation to maintain the premises in a condition that is habitable and that complies with the state health and safety code. A landlord cannot ask a tenant to sign a lease or contract that waives the landlord's responsibility to provide a habitable dwelling. Question number 5. Who pays for the damage to a tenant's personal property? The answer to this question depends on whether the landlord failed to maintain the property in a way that would have avoided the damage. For example, if the landlord failed to keep the roof from leaking, the landlord should be responsible for damage to the tenant's property that occurred with the heavy rainfall. A tenant whose landlord failed to properly maintain the property can write a letter to their landlord asking for reimbursement. If the damage to the tenant's property was caused by conditions outside of the landlord's control, the landlord may not be responsible for the resulting damage. For example, if the tenant's property damage was caused by the flooding of a city block, a tenant in this type of situation may be able to file a claim if they have renter's insurance, but would not likely be reimbursed by their landlord. Tenants should document all damage to their property caused by the floods through pictures and videos if they haven't already done so. If a landlord refuses to reimburse a tenant, the tenant can contact a private tenant attorney or file a case in small claims court on their own. To file an action in small claims court, a tenant should be prepared to explain why the damage was the landlord's fault. For example, my apartment flooded because the windows were in bad condition, or my apartment flooded because it is at the bottom of a hill and my landlord did not install a proper drainage system. Legal Aid Society of San Diego has prepared some sample letters that can be used by a tenant to write up their own letter to the landlord to seek reimbursement for the expenses discussed in this video. A tenant can download the sample letters and change the information to apply to the tenant's specific situation with their own personal information. These sample letters and other helpful resources can be found on the homepage of the website www.lassd.org by clicking on the words Learn More, located underneath Guides for Storm-Related Information. Thank you for watching. As a reminder, the links to the website where the sample letters can be found were sent with the link to this video. If you believe your rights have been violated or are in need of legal assistance, please call Legal Aid Society of San Diego at 1-877-534-2524.